Okay. So we are on to chapter 8, tracking along with our book, and pretrial motions, hearings, plea negotiations. This came up a little bit even in our chapter 6 information, so some of it's similar, but just hang with me. And as always, you are free to unmute yourself and chat a question. And actually, I don't know if anyone wants to volunteer to be the chat master, because when I'm in this mode, I can't see the chats. It won't display them. So does anyone want to volunteer to be the chat master? Zoom. Alrighty. So you have to kind of think of the lifespan of a whole case. You know, there's a crime committed, you know, allegedly, you know, but a crime is committed, and then someone gets arrested, right? And then from there, they're going to get charged with the crime, and then things move forward. Okay, and even when they get charged, you're going to have, you know, obviously arraignment right after their arrest, and you're going to have preliminary hearing. And then from there, you'll move closer to trial. So this is sort of taking you through maybe that moment after prelim, but before trial, okay? So you have a lot of motions that are filed. And you know, it could be different legal arguments, it could be any number of things, and they'll mostly deal with evidentiary issues, meaning the evidence that would be presented, and you know, whether or not that confession is going to be allowed in, whether or not that witness statement, whether or not the lineup, you know, will be allowed in, you know, when the witness identified the defendant in the lineup, will that be allowed in? So at any rate, right, so you have a document that's filed, an affidavit, and then there will be like an oral hearing, you know, where everyone will get to make their arguments for and against. One of the things we talk about that happens obviously after you've been arrested, arraigned, you know, and really probably even starting from that moment forward, but certainly after the prelim, is the pretrial right of discovery. So this means that the defendant must be allowed, and really both sides, to inspect, review, see all the information that the other side has about them. And frankly, if you follow a lot of criminal law news and cases, this area is one of the areas that if people mess up, it can have very serious consequences. So when people don't disclose evidence, when they don't turn over the evidence, when they violate this right of discovery, you can have big trouble. So one of the cases I'm thinking of from a few years ago that you may want to look into was the Duke lacrosse players who were charged with rape and were tried. That in the end, it kind of came out that the district attorney withheld evidence that was exculpatory. So exculpatory, not culpable, right? Not culpable, evidence that would make them look not guilty. So you have inculpatory evidence and you have exculpatory evidence. In, meaning it makes you look guilty, ex, meaning it makes you look not guilty. So exculpatory evidence. So if you're a defendant, exculpatory is like the most important kind of evidence, because that's the evidence that shows that you didn't do it. And basically what happened was the district attorney withheld the evidence that showed the defendants didn't do it. And then at the end, all that, you know, they were either convicted, not convicted, or the convictions were overturned. The district attorney was fired. I think he even was sued personally. I mean, it was a huge disaster. But anyway, so really important. And California, we have some of the most extreme version of this. Maybe that's not the right way to phrase it. We always have maybe the most protection for the defendant. And so we have the most requirements for both sides for the prosecution to turn over its evidence that they have to the defense. Right? So obviously the right of pretrial discovery, it's created to benefit the defendant because it helps them plan, prepare, you know, should I take that plea deal? Well, I don't know, how much evidence do they have against me? So obviously under federal rules, you can pretty much, and in California especially, can see everything. Names and addresses of witnesses, anyone that the government intends to call in their case, you're allowed to know that. And partly again, because you need to prepare for the confrontation, right? You know, think of the confrontations clause. You want to know who's going to be coming before you. If you deny them the pretrial right of discovery here in California, a big no-no. Your whole case can be jeopardized. So that's considered a violation of their rights. They, you know, are allowed to know the evidence before the trial happens. So I know we love all the dramatic movies where there's like the surprise witness and oh my gosh, you know, and dun dun dun, and the doors open and it's like, holy cow. In real life, that doesn't happen. In real life, the witness list is presented, you know, maybe several months in advance of the case. It's presented through specific motions to the court. The judge sees it. So even the judge would be just outraged to have a witness that wasn't on the list come forward. Now, what happens is you make the witness list. You may not end up calling every witness, but all the names that you think you might call have to be presented on that approved witness list sheet. And then whether or not you call every witness, that could be up to your individual trial strategy. But you can't bring a witness forward that no one had ever heard of, that wasn't on the list, that, you know, totally shocking. So I know we love that in all the movies. You know, it might be shocking what they say, right? They might say something you're not expecting. They might not perform as well as you thought they would. They might perform better, you know, but the fact of a witness itself should not be surprising. So yeah, that can be. And then right here, this idea that the prosecution gets it as well, that's what we call the reciprocal, meaning like we each get to see what the other has. And the idea really here is that it helps us narrow, it helps us understand the value of a case. You know, like if you have evidence that you didn't do the crime, I also, if I'm the prosecutor, should see that, because maybe I should drop the charges. Maybe I should go against somebody else. And it's, you know, judicial economy, efficiency, you know, we don't want to go to trial if we don't need to. So if you have evidence as well, you may be forced to disclose that, right, to the other side or to the prosecution. Brady, oof, we may add Brady in as one of our mini briefs for later. I'm making a note to myself. So Brady is a very famous case, and we may get into this separately, but this is if you have anything exculpatory, right? Any evidence that might show the defendant either didn't do it or would help them defend themselves. It basically must be disclosed. And in California, it must be disclosed. So what that can look like in real life, you know, think of a lot of you are familiar with the O.J. Simpson case, deeply familiar with it at this point from all the documentaries. You know, the fact that Mark Furman, right, one of the police officers who was working on the case, was later had those tapes where he used, you know, racial epithets or something. That can be exculpatory, right? Does he have biased views? You know, maybe you have a police officer who, a case from a year ago, right, forged evidence or falsified a report. Now, that's totally separate case. That's a case from 5 years ago, right? This is a case from today. But the fact that that happened 5 years ago is exculpatory because it might lend some credence to the defense's argument that maybe that officer is lying now. Maybe that officer falsified evidence now. So obviously, oh, you know, we tested your DNA and you weren't a match. That's, you know, that's the easy version of Brady. The much more difficult version is, you know, the defense doesn't know the human resource record or the internal discipline record of this police officer, of this agent, of this FBI investigator, of this DEA agent, of this ATF agent, right? The defense doesn't know that. They might ask for it. And maybe there was 30 agents that worked on this case over the course of time. So the government has those records in their custody, in their control, and they are aware of all those personnel records and any discipline actions that have happened. And if there is something that really does affect like their credibility and their ability to be a good officer, that is considered pretty much always exculpatory, and is very, very concerning. So for many of you who are thinking of a future in law enforcement, you do need to be thinking really even from right now about protecting your professional reputation, your reputation for honesty, your reputation for your good work. So even if you're like a brand new police officer or in the academy or things like that, you want to always be mindful of any kind of disciplinary action, and hopefully that would never happen. But having a really clear understanding of is what's going to happen. Is this a future Brady issue? Because once you've had, right, something, oh, you were found to be, you perjured yourself in court, you gave false testimony, you know, not an honest mistake of, well, we thought that was the guy, but you actually knew that that wasn't the right person, or you falsified a record, or you tampered with evidence. You in some way become kind of kryptonite, because any case you now touch, they're going to have to disclose to the defense that this happened in the past. And that immediately, it may be totally have nothing to do with the current case, but the defense will make it, right, seem like, well, they did this before, they're going to do it again. And that'll be part of their argument. And so that is considered exculpatory. So very, very, and sometimes when you get more involved in your career, it might help you understand why some things, you know, that maybe you're late for work or something, it's handled, but they're very careful about how they couch that, because that's not, you know, they don't want that to be thought of as Brady or anything. So we may look more into Brady next week, just because it's such a big issue. And especially for you thinking of maybe a career in law enforcement, you want to just, you know, do everything by the book and by your training, and always be aware of your own reputation and protecting, you know, not so much your reputation with your neighbors, but your professional reputation. And that it's one thing if a defendant is found not guilty, or someone doesn't agree, but that you are always telling, you know, the truth and seeing, you know, from what you can control, you know.
Professor?
Yes.
Maya said something in the chat. She said there are new laws now that make police officers record available to the public, and the police stations are still in the process of developing systems to release it through when requested.
Yes, so Maya is totally right, and she's on the front lines because she's working. I think it was it passed in January that, yeah, police records have to be available, like their entire record. And it's also to support the efforts in finding some of these things out. And it's so new that there is a lot of turmoil, maybe, but it's part of a lot of those criminal justice reforms that I think was passed in January. So yeah, your entire kind of police record has to be made, it can be made, you know, will be made available to the public for review, but the real issue would be by the defense counsel, you know. But yeah, thank you, Maya, for jumping in. Yeah. Any other ones, Michaela? So we might come back to this because it's such a big issue.
And then Aaron said, didn't they tamper with OJ's blood?
Oh no, I don't know. I mean, that was their argument, right? That was OJ's argument. And you know, I really, really cannot recommend enough the OJ Made in America documentary, like the 5-parter, 6-parter documentary. I lived, you know, I was alive, I observed what was going on with the OJ stuff, and it even had details that I, you know, had forgotten or didn't understand, or it was incredible. I have a new understanding of the jury. I'll say that for sure. But yeah, that was their argument that, hey, maybe, because I think it was Furman was someone that collected like a key piece of evidence. And they used the fact that he had those tapes to say, you know what, he was biased, he's racist. And so maybe he planted evidence, you know, and it was powerful, right? It's a powerful argument. But I don't know about the blood. There was a lot of blood. I don't know if they tampered with it. I think the better thing to watch if you're interested in the tampering of blood is the Making a Murderer documentary, which I can't believe I haven't specifically mentioned in the past like couple weeks. Netflix. So it is a Netflix thing. It's like a 7, 8, 9 parts. Making a Murderer. Amazing. Really good. So that's another, if you've got the time. On that one. Any others, Michaela? Our tribute?
No, that's it.
Okay. I'm going to start calling it tribute instead of Chatmaster. Okay. So, oh dear. Anyway, we're not going to worry about this right now. It's just federal, but okay. So then we get to the next big motion for pretrial work. Motion to suppress evidence. In Latin, we call it motion in limine. Limine. I'm not going to type it out because I'm in the chat. Limine. So you can kind of see the limit, right? To motion to limit, motion to exclude, motion to suppress. So this is huge. Right? You are arguing that there is evidence that was obtained that somehow isn't proper or violated their rights, violated, any number of rights, right? And therefore should be excluded from the case. And you have to remember, this is an absolute rule and it's very powerful. Imagine that I want to charge you with possession of drugs for sale, quantity for sale, drug trafficking, 50 pounds of meth that was found in, the back of a truck, like in pipes in the back of a truck. And so the motion to suppress is all about the 50 pounds of meth. Did I violate Fourth Amendment? Did I have a warrant? Did I violate your Miranda? Who knows what, right? Any number of things might have happened. If the defense wins the motion to suppress and the 50 pounds of meth that was found in the pipes in the back of the truck is excluded, that means the prosecutor cannot mention it at all. They can't say a single word about it. So you almost have to imagine that they go to court and they're like, Your Honor, we want to charge this person with, possession of quantity for sale, drug trafficking. And there's like 5 elements, well, one element is it's a certain amount, right? It's both possession of a drug and an amount like, 5 pounds or kilos or whatever, it's more than just a couple baggies of meth. And so the judge is like, well, what was there? And you're like, we pulled over the truck, we inspected the pipes, and then we found. You are not allowed to say that. You're not allowed to say we found meth. Like, you can't say it. We can't say it because it got excluded. And the judge is like, well, what? And then the judge is like, well, the fourth element is what was the quantity. And you're like, you literally have a hand over your mouth. You can't say we found 50 pounds of meth because it's excluded. So then the judge looks at you and goes, you don't have the elements. You don't even have the most basic elements of possession for sale, for quantity. Like, we can't even go on with the charges, right? I mean, it's like you've taken a giant eraser and you've erased it. You can't even, we don't even have probable cause to move forward with the charges. So suppressing the evidence is a huge deal, right? And for most of the time, this is really where criminal cases are won or lost. If the 50 pounds of meth comes in, you're probably going to be convicted, right? You probably won't even really go to trial. You'll take a plea. But if the 50 pounds of meth comes out, then you're walking, or you're just going to plead guilty to a broken taillight, right? Which is an infraction, which is a little $50 fix your taillight thing. So the motion to suppress or motion in limine, very, very, very important. And it can come from multiple areas, right? It could be, a due process right. It could be, Fourth Amendment, Fifth Amendment. It could be a confession that you made is getting suppressed. It could be something that violated a warrant. It could be any number of things. But this is really what will set the stage for what happens next. If the dead body gets suppressed, then they probably can't charge you with murder. It's not impossible, but it's going to be very hard, and it's going to be really hard for them to win the case, And so that's where that kind of decision about the plea bargains start happening. So huge part of the pretrial. So what they'll do is, before you go to trial, you'll set the landscape of what evidence is going to come in and what evidence is going to be left out. So that way, once we have the jury, we can just sort of move seamlessly through this. We're not going to have these debates that, because this could take, certainly several hours. These are some of the biggest fights ever. And, and you have really in-depth legal arguments and documents that are submitted. You might even take testimony about the evidence and how it was collected or what happened. Was it a knowing and intelligent voluntary waiver of their, right to counsel or of their right to speak, like all of that. So this will all be done before the trial. And then the help is once you know what you're faced with, once you know what the universe of evidence is that's actually coming into the trial, it gives you a really good sense of like, ooh, how, you know, what are my chances of getting convicted here? So huge, huge part of the deal. Questions on this one? Or just thumbs up? Okay, our tribute is not speaking, so I think we're good. Okay. So again, it's obviously before trial. It's outside the presence of a jury, and that should make sense to you because if I tell them there was 50 pounds of meth found in the back of the truck, like they're not going to be able to delete that from their brain. They're always going to know. So you don't want the jury to hear anything until it's certain it's going to be allowed to come in. So usually it'll be done in that, you know, month or two or even earlier before trial. And it's simply the decision's made by the judge because it's about the legal standards now. Did this evidence comport with the legal standards? It's not about whether or not necessarily, you know, guilt or innocence at that point. It's just about whether or not the evidence was gathered properly, you know, did it comport with all the constitutional requirements and that sort of thing. So before trial. Any questions on this one? Okay, so typical grounds that you might see, some of them we've already previewed a little bit. You know, again, on the confession, was it not a knowing and you know, voluntary waiver? Like, were you know, was it an involuntary confession? You were tortured or you weren't allowed to see your lawyer, you know, when we looked a lot at that at some earlier chapters. You know, did you revoke your consent, that kind of thing? Maybe the mental capacity of someone to make that determination. Okay. Evidence, you know, was it an unreasonable search, an unreasonable seizure? You know, was there a defect in the warrant? You know, sometimes a defect in the warrant is not a problem. You know, it was a typo and there are some good faith exceptions there. Or was there a legitimate defect in the warrant that invalidates it? Perhaps there wasn't a warrant, right? And they just went kind of off a probable cause exception in the moment, but they're looking at that differently now. And, you know, the determination, and this is where you can also see the interplay of, you know, the law enforcement and the attorneys. You know, the determination the law enforcement agents made in that moment, right, as they're doing their duty, is now being looked at 12 months later by the attorneys and the judge, and maybe the judge sees the probable cause differently. Maybe they're like, you didn't have enough, you should have had more, or, you know, so, and that does happen, right? That a search, a seizure is found to be, you know, unreasonable and violates the Fourth Amendment. Questions there? Okay. So after a complaint, the information or the indictment has been filed, you know, basically the charges are there. Then we move into, you could have a motion to dismiss, right? Once the charges have been filed, depending on different reasons. And they have the nolle prosequi, which I think just means they're not going to prosecute for some reason. So they would enter a non-prosecution. I think the next chapter, I can't remember if it's later on here, we would be talking about, yeah, like a plea of no contest. Yeah, no contest. But we'll get to that in a second. Ooh, sorry. Are you guys seasick? Okay. So again, the continuance issues. So you could, in this run up after you've been charged, you know, ask for a continuance before the trial. So it's very much in the defendant's favor for this. Pretty much where a defendant asks for a continuance, I guess I should say up until a certain point, it's very much granted. If they need more time to prepare, things like that. They are the ones that can waive time, is sort of the phrase. However, if it's gone on for long enough, then they might really look to the prosecution. But if the prosecution agrees to waive time, then it would be waived. And even sometimes if they don't agree, the judge would say, yeah, we're going to give the defense more time to prepare. But if the prosecution wants more time to prepare, that's where they will say no. If the defense wants to move forward, if the defense doesn't want to waive time, they have their right to their speedy trial and it will move forward. If the defense asks for more time, that will often be granted. Where you might see the pushback is if it's already been continued you know, maybe several times or for a decent amount of time, and they want another continuance or more, the prosecution could say, you know, the victims really and the law has an interest in having this case move forward. And so the judge could take that and say no. But often the motion for continuance is really defense facing and done to make sure they can be fully prepared. Any questions so far? I know I skipped a couple of things, but I can't see any chats. Okay. Our chat master is telling me I can keep going, I guess. Okay, severing offenses. So this is where you've been charged with maybe 3 crimes, okay? I know all of you watched Tiger King or have watched it or have heard about it, right? So Joe Exotic was charged with what? Multiple things. I don't have the list in front of me specifically, but one of them was the murder for hire plot. Okay, oops, that's a big one. The, why can't I think of the name? The, what is that called? The conspiracy, I'll get there, it's a C. Conspiracy to commit, you know, murder, trying to hire somebody. And then there were other charges about like animal abuse and maybe like killing animals improperly, you know, and those, and so if you've watched a lot of the commentary, there's a lot of discussion of, well, the animal abuse, yeah, for sure, that seems pretty well documented, pretty easy to say that that was happening. But the count or the offense of the conspiracy to commit murder, the murder for hire, that seemed to be a lot more of a closer call, right? So Joe Exotic, perhaps his attorneys should have motioned to sever those offenses. And what does that mean? You'd have 2 different trials. You'd have one trial over all the animal abuse stuff, and you would have a separate trial over the murder for hire plot. And the theory is, and this is very much focused on the defense, you know, maybe he's going to get convicted for the animal abuse. And that's very, you know, people are like, how can you hurt an animal? That's so awful. It's a very, there's like almost a weird psychology, right, about animals versus people. But so the idea is that for the next case, you wouldn't let the jury hear anything about the animal abuse. That jury would only hear evidence about the murder for hire. And they wouldn't hear anything about the tiger shenanigans and whether or not he was hurting tigers. And so maybe if they don't hear that evidence, they're just going to focus on the one count and the story in front of them. And they're not going to have any emotional thoughts about the animals, and there won't be any kind of blending. So, you know, that's interesting that like his defense, I mean, maybe they did motion and it was denied, we don't know. But so, right, so when you put a whole bunch of charges together, right, it saves time, it's efficient, you know, it might be the similar witnesses, and you could see that with that case where it's like the same 5 witnesses all have the information about the animal abuse and, you know, the murder for hire plot. So that makes some sense because we don't have to keep calling them back forward and yada, yada. But I think if you're on his defense, you could really make the argument that animal abuse, I don't know what the potential time that he'd be facing, but that's, you know, it's far less than the murder for hire. So very interesting. And that's right, I just brought in Tiger King and wasn't even planning to do it. So you guys are giving me some ideas, but Michaela, our chat master, our tribute. Any questions? I'm assuming none. I'm just gonna keep going. So right, yeah, this is basically what I just said. Thank you. You can also see severance when you have multiple defendants. So you could have multiple charges or multiple defendants, what we would call co-defendants. So when you have like 2 people charged with a gang offense or a drug crime, part of what might happen is that actually defendant A wants to blame defendant B, and maybe defendant B wants to blame defendant A. So if they're sitting next to each other, it might be hard to do that. It might not play as well for the jury. But if we say, you know what, you're gonna split us up. You're not gonna have the same case with the same jury at the same time for both of us. We want separate cases, separate juries, and you will sometimes see where they'll have separate juries, like 2 groups of jurors watching, you know, for each co-defendant. So that way they just consider one, but you could argue, no, I want a completely separate case. You know, maybe maybe I'm representing the 20-year-old that pretty much has never had any criminal record, and he was asked by his older brother to be the getaway driver. So he was just waiting outside the 7-Eleven. He didn't know they had a gun. He didn't know that they were going to shoot somebody, So when they walked in and they shot the 7-Eleven people and maybe a customer, so now they've committed 2 homicides. The brother, a couple friends, they jump in the car and the 20-year-old drives them away. Well, under felony murder rule, the getaway driver, the 20-year-old, could be charged just the same as his brother and his brother's friend for the homicides. So the 3 of them are now charged for homicide, right? LWOP, life or life without parole, maybe even death penalty. And you're saying he was a 20-year-old, he was a 19-year-old. He literally has only ever had a shoplifting charge. He didn't even know what they were doing. So I don't want the 3 of them together in the same trial. I want totally separate, because we're going to present all kinds of evidence about how he didn't know, and maybe he was manipulated, and all this information, and he's had a totally different life path than maybe his brother, who is a very hardened criminal, or his friend who's been involved in very serious things. So the severing could be on the charges, but it could also be on the co-defendants. And questions on that one? Okay, I'm giving myself a thumbs up. That's what it's come to, you guys. I'm giving my own self thumbs up. It's bleak. Oops. Okay. Now I'm just laughing at myself. Any rate, so motion to determine competency. I briefly mentioned this, I think, last week, that, you have 2 different things when you think of the mental states. You have the mental state of the defendant at the time they committed the crime. Okay. And remember, if I had a better graphic, but I'll just have to use my 2 fingers. When we have guilt for a crime, it's the confluence, right? It's the coming together of 2 things at once: the actus reus and the mens rea, the action and the mental state. So when they come together at the same time, you can have guilt. Okay. That's your requirement: action and mentality. Insanity as a defense is powerful because it negates the mental state. So you have the action, but you don't have the required mental state. So therefore, you cannot be found guilty. Okay? So that is your insanity, not guilty by reason of insanity. That is for guilt. But we have another aspect of mental competency that comes into play, and that is competency during the proceedings. So you may have been competent when the crime was committed. You're not claiming insanity, so that's not an issue. But maybe because you have been in jail, maybe you're not getting your proper medications, you're extremely stressed, maybe the phrase would be decompensating, your mental health is degrading, or again, you're not getting your medication properly. You're suicidal, right? Because you're facing these very serious charges. So you must be competent during the proceedings. And it's because the person has to be able to direct their own counsel and make decisions for their own case. Like, are we going to plead? Am I going to take the stand? What sort of defense do I want to mount? So if they are not competent, the proceedings must immediately pause, and we cannot go forward. And this is a serious issue, and it literally should be looked at for every single part, pre-trial hearings on up into trial. So you will see times where maybe someone's medication got messed up and they're having an episode, and they'll have to take time to work with the psychologist, psychiatrist, to get them, competent so that they then can go forward the proceeding. But that will absolutely halt the proceeding. And like we mentioned last time, if someone is acting out, there has to be some discussion of, are they doing it on purpose? But they actually might be acting out because they are, their mental state is degrading, and they're losing the ability to even control themselves. So if they're shouting out or yelling, it could actually be a sign that their mental health is going down, and therefore that needs to be looked at, because perhaps the proceedings cannot continue. So any questions on that one? I know we've done a bunch here, and we're getting towards the end. Okay. So then we go to pretrial conference, and this can sometimes happen throughout really the time. So this is where both sides would meet with the judge at the same time, right? So you'll hear some judges say, their phrase is 2 at a time. They always have a prosecutor, always have a defense attorney. together so that there's, you know, no impropriety. They may also have them on the record where a court reporter, so even though they're in chambers, like in the judge's office, it's not in court with the jury, but it's, you know, it could be 6 months before the trial. They're discussing, you know, how much time they think they need for the trial. Is this a 1-day trial? Is this a 3-month trial? You know, how many jurors, you know, you obviously have 12 jurors, but, you know, maybe we think we're going to have a bunch of jurors that are going to be, you know, more serious case, unable to be on a long jury. So do we need to call 200 or do we need to call 500 for the panel? You know, is there a chance of settlement? What kind of evidentiary issues? So just sort of this discussion ongoing as they're working towards everything. You know, it could be the defense counsel could be saying, my client isn't getting proper medical care, right? And is degrading. And so, and needs proper medical care. Plea negotiations. This is another huge area, right? Plea negotiation, plea bargaining. There's a lot of pluses and minuses, right? And I think if you have a social justice focus, there's a lot being written about this and looked at. You know, plea negotiations, you know, is it legit? Is it good? Let's see here. I'm just seeing, Michaela, is there a question on this one? Oh, okay. You're right. So, you know, the goal of a plea bargain would be to say, you have the chance to get a better deal than if we go to trial. Like if we go to trial, you know, this is what you hope, right? That in the best case scenario, someone sees that the evidence is so overwhelming, or maybe they know they did it. You know, I mean, they're sort of like, I can face that, I did this. And they know that if they go to trial, it does take up a lot of resources. You know, it's the jury's time, it's the victim has to go through this, you know, everyone has to go through this. And yet, if they know they did it, if they know the evidence is overwhelming, you know, you're going to get convicted to like 25 to life, versus if you are willing to take a plea bargain and kind of prevent everyone from having to do this, we'll give you a lesser charge, right? You will plead to what's known as a lesser included offense. And maybe that only has 15 years. And so when you get into, I think, your other criminal law classes that focus on, you have like the charge, and then when you look in the penal code, you have the lesser included offenses. You can see, so let's take murder. So you have murder, like first degree murder. The lesser included offense to first degree murder is a voluntary manslaughter, right? You have second degree murder. The lesser included to second is an invol, right? Involuntary manslaughter. And so are we going to charge you with first, or are we going to go with a vol? You know, or maybe if you watch, was it Law and Order, they call it manslaughter 1 in the first degree to match first degree murder. So understanding that, you know, that again, it's sort of the trade-off of, you know, 15 years with a definite out date versus 25 to life, where I may never get parole or probation, you know, at that point. There's been a lot of work done on this. I mean, so you can kind of go deep down the rabbit hole on plea negotiations, but it really should be about, you know, and maybe there's a weakness that the prosecution has, and so they're offering to the defense something. Maybe there's a weakness the defense has, right? And so they're offering something to the prosecution. Plea bargaining. And you can also see it for, you know, giving information and being a witness, and I think that comes up a little later. Any questions so far on this? Oh, and there's more slides, so you can look at that, right? Reducing the charges, you know, that kind of thing. Maybe we'll pick up right here. So what's interesting is that you can have a plea bargain and someone accepts the plea and pleads guilty. And at every point, you know, again, thinking back to what the work you guys did on for the midterm, you know, even a plea, it's not just between the prosecution and the defense. It still has to be presented to the judge, and the judge still has to sign off on it and say it is acceptable. And they will still expect the defendant to make a statement, to enter like a plea colloquy where they go through, yes, I did this, and yes, I understand the consequences, and yes, I'm a free person and I haven't been coerced. And there are times when a judge will say, I'm not going to accept this plea. Something's not right here, or whatever. So it's not a guarantee, right? So again, each branch, you know, has a role to play in even looking, and the judicial branch even has a role to play in a plea that they might say no. But if it's all been accepted, right, you know, prosecution, defense, even the judge, and then something comes up later, it is entirely possible they can make a motion to withdraw their plea, right? If they find out you hid evidence from me, I didn't know you had evidence that I didn't do it. I've been saying I didn't do it, but I didn't know that you were hiding evidence that I didn't do it too. So I want to withdraw my plea. And probably the biggest case of the threat of having my YouTube link be outdated. One of the more interesting ones where we're seeing this right now potentially is with the Michael Flynn, that General Flynn person. The thought is that he is going to make a motion to withdraw the plea at some point that he made. And this is a little bit down the weeds, but if you want to look into that, that's an interesting one where it's playing out in real time. So, and that's why in the previous slide, they kind of mentioned Brady. So if, you know, the prosecution hid evidence that would have helped you prove you weren't guilty, and they didn't tell you, oh, we got all this evidence over here that actually shows you didn't do it. We don't want you to know about that though. And kind of tricked you, you know, into thinking the case was really strong and tricked your attorney. And then you plead guilty. That's the kind of thing that you're like, wow, if I had known that I actually had 5 witnesses that could have come forward saying it wasn't me, I would have never taken this plea. I was facing what I thought insurmountable. There was nobody, there was no evidence. So those are the kind of things that would be very bad that you want, where the defendant really needs to know, look, these are some weaknesses. This is all the evidence you have that could help you, but here's why, you know, we still think this is a good plea, whatever. So again, a really informed, knowledgeable decision there. We're basically at the end. So any other questions? Let's see, Michaela, I'm gonna stop the share so then I think I can see them. Let me see here. Maya has a comment. A lightweight, especially in a criminal case. Oh, is this for severance? Yeah. So you're right. So, you know, when you have someone that, when you think of severing the charges, you have like 4 co-defendants. If you have someone that has a very different criminal record, meaning they really don't have a criminal record at all, and the other 3 people are the heavies, you know, the people with the extreme records, you really do want to pull this person out for their own trial. You know, you don't want them sitting next to really serious people with like serious criminal records, because it is partly persuasion. So yeah, so when you have someone who's more of the lightweight versus the heavies, you really would want to sever them out. So I think that's really true. Yeah, and Maya saying she's working on that. So any other thoughts or comments on the lecture information? Otherwise, I will stop the recording in a second. And then just remind you of your assignment for this week, or maybe I'll keep the recording going. So let me just take you to your assignment. Oops. Over here. Anyway, so let me just remind you of your assignment for the weekend. We have a bit of a weekend here. So Module 7, so you have the quiz you're working on, okay? And then the mini case brief for US versus Gonzalez-Lopez. And right now there's no assignment for Chapter 8. So this is all you're working on over the weekend. It's due Tuesday before class. My hope is that we can come in and have a good discussion on Tuesday about Gonzalez-Lopez to kind of finish up the assistance of counsel. So if you're just popping in, that's your work for this week, and they're both due Tuesday. So that should be pretty easy. And then I am gonna turn off the recording.